Good morning, everyone, and welcome to this webinar on protecting your food and beverage business. We're delighted that you could join us for what promises to be a very interesting and useful set of short presentations designed to help business owners identify and manage the various different risks and issues that can arise when seeking to protect their food and beverage businesses. I'm Jamie Gallagher, and I'm going to be acting as MC, and it's my pleasure to be able to introduce our speakers this morning. So we're joined by Matthew Morris, who's an Audit and Investigations Manager at the Food Safety Authority of Ireland, Jerry Kelly, who's partner and head of our intellectual property practice here at MHC, and also Ronnie Neville, who's a partner in our employment law and benefits team. So in terms of our agenda, we're going to begin with some insights from Matthew on food safety culture and how to effectively communicate with food safety regulators. And then Jerry is going to bring us through some recent IP case law developments that are relevant to the food and beverage industry. And then we're going to finish with Ronnie, who's going to cover some recent and also upcoming employment law developments that are also relevant to the food and beverage sector. And just to quickly note in terms of housekeeping before we kick off, that there is a Q&A function in the panel below the speakers, and we will have time at the end of the session to address the questions that you input into that at the end of the session. So please feel free as issues are being discussed to input anything you'd like to learn a little bit more about. And without any further delay, and with thanks to the FSAI for agreeing to be part of the session, I'm going to firstly hand over to Matthew, who's going to bring us through our first segment.
Thanks, Jamie. As Jamie mentioned, I'm an Audit and Investigations Manager with the Food Safety Authority of Ireland. I've been with the authority for just over 4 years. Prior to that, I worked as the Regulatory Services Manager for London Borough of Ealing, with looking after commercial regulation of business premises within the borough. And before that, worked as an Environmental Health Officer for a number of London and home counties local authorities. So I have a background mainly in food safety regulation with a little bit in health and safety. If we can get the next slide there, please. This morning, I'm just going to speak to you very briefly about communicating effectively with food safety regulators. I think communication in this area can be a little bit different, maybe with communicating with other types of regulatory agencies, particularly with the shared goal being consumer protection. I think it's fair to say that most contacts between regulators and regulated entities in the food safety space are fairly frictionless. Most of them happen during routine official controls. An inspector, be it an EHO or a veterinary inspector or another type of food safety inspector, arrives at your business, conducts a routine inspection, takes routine samples. Maybe you'll get a report asking for some corrective action to be taken. Mostly corrective action is taken, and you'll see your inspector again at the next routine visit. Occasionally, perhaps there might be some disagreement around the content of the report, and I think also it's hopefully fair to say that mostly those types of issues can be resolved pretty easily through dialogue with the inspector. But I'm going to speak to you this morning a little bit about maybe something perhaps a bit less routine, maybe more of an incident or a crisis situation, and communication in that context. So we'll just get the next slide again, please. So we'll imagine it's Monday, you're running a food factory, you're making some sort of ready-to-eat food that gets distributed to retailers such as supermarkets. So it's a busy morning at the factory, your inspector arrives, they've arrived unannounced as they usually do, and they're just here to take some routine food samples for listeria testing. They've done this many times before. There's never been an issue. You're not too worried. So the inspector deals with your technical manager. Your technical manager is being super helpful, and the inspector takes 5 samples from a batch that's about to be dispatched to the supermarket distribution center. So the technical manager is being super helpful and returns to their planned work for the day. So this is totally routine. It's interrupted the technical manager's work for the morning, but they've dealt with it and they're moving on. Your technical manager is not worried because you have a good history of own check sampling, and you're carrying out your own testing regularly of food and the environment, and all the results recently have been fine. So there's no cause for concern and everyone has moved on. So we'll get the next slide, and we're fast forwarding now to Friday. It's Friday and the results are in, and unfortunately it's not good news in this case. So it's nearly 2 p.m. The technical manager receives a call from the inspector, and unfortunately Listeria monocytogenes has been detected in 2 of the 5 samples they've taken from the same batch. And for those who come from a technical or quality background on the webinar today, you'll be aware that the regulated limit for Listeria in certain ready-to-eat foods at this point in the supply chain would be absent in 25 grams in all 5 samples. In this case, the batch has already been dispatched. We'll imagine the batch has gone to a supermarket distribution center. It's gone out to the individual stores within that supermarket chain, and there's 7 days shelf life remaining or thereabouts. So the inspector informs your technical manager that the FSAI incidents team have been made aware and advised that a product recall should be initiated immediately. And the inspector asks for full distribution details in terms of the names and addresses of those stores that have received the product, so that they can liaise with local inspectors and verify the effectiveness of the recall that they've asked to be carried out. So if we move on to the next slide, please. So internally in the business, the technical manager is going to notify the managing director or perhaps their line manager. It might be that a crisis team is convened, depending on the size and the scale of the business. The business has its own sampling results for the same batch, and the business's own sampling results indicate that Listeria is not detected in 5 out of 5 samples. So there's some discussion and feeling, could this be a sampling or analysis error by the official laboratory used by the state inspector? And there's a little bit of chatter about being eager to avoid a recall and the potential for brand damage around that. And the business is having discussions around that, what approach to take. So if we can get the next slide, please. So if we could just bring in the first bit of the animation here. Thank you. So typically we see businesses take one of 2 approaches in this type of scenario, depending on their prior experience, maybe with recalls and food incidents, and also depending on the prevailing attitudes and food safety culture within the business. Now, fortunately, most businesses take the approach outlined in the first column you see on the screen here. So they assume the results are correct, or at least that they may be correct, and are happy to adopt a precautionary approach, immediately initiating a recall, ensuring the products are off the shelves, particularly in this case, the call has come in on a Friday. And just for the benefit of those on the call, we see quite commonly with the official laboratories, they're busy doing the analysis during the week, and Friday samples aren't coming in, and that's often the day that sampling results are reported. So, unfortunately, these kind of calls tend to land sometimes on a Friday afternoon when the lab are busy reporting all their results from the previous week's work. And businesses might then immediately initiate the recall, ensuring all the products are off the shelves before the busy weekend period. And even if there's lingering doubt in their mind on the accuracy of the lab results, they're taking this very precautionary approach and providing reassurance to the inspector that the matter is being taken seriously and the product's being urgently recalled. Unfortunately, and if we bring in the next bit of the animation, we see a small number of food businesses that are happy to waste a lot of time arguing the accuracy of the results. So they're treating the results as incorrect because they contradict the business's own results for the batch. They want to buy some extra time to consider the matter, maybe conduct extra testing. They undertake to revert perhaps the following week, and the products might remain on sale over the weekend over a busy trading period. So just a couple of points on this type of approach in terms of communicating with regulators. The first approach that's been outlined, that's likely to instill a lot of confidence in the regulator, obviously. And the second approach, I suppose, is likely to strain relations to some extent. The other thing I would mention around, and again, for anyone from a technical or quality background, this is something you'll be well aware of, both sets of results are probably correct. With microbiological contamination, such as Listeria in particular, it often tends to be present in food in low numbers and also be distributed in a non-homogeneous way in the food. So if you take a production line, we'll say for cooked sliced meats, maybe there's Listeria in a harborage site in a slicer or something like that. It's being exuded inconsistently from that harborage site. It's only contaminating certain units that are passing over the line. So not every slice of ham coming off that line is getting contaminated. Or maybe there's Listeria on a sealing surface and it's dripping down in condensation. And again, it's just inconsistently contaminating products. So it is entirely possible to take a set of samples and have satisfactory results, and take another set of samples from another part of the same batch and have unsatisfactory results. Generally, in my experience, it is not helpful to waste time arguing results like that. Generally, these products on the market for longer than necessary increases the risk of actual harm to consumers. And I would just urge businesses adopting an approach like this to consider how it would play out in the event of actual harm to consumers, particularly if it emerged that the business was made aware of an issue perhaps before a weekend and products remained on the market over the weekend, as an example. Just to flag on this point as well, And again, for those from a quality or technical background, you'll be familiar that there is greatly increased use of whole genome sequencing when it comes to investigating outbreaks and incidents. And what maybe appear like disparate human cases of something like listeria can now be easily matched genetically to a food isolate. And we have seen examples of that, and we continue to see examples of that. So I would urge businesses to adopt a precautionary approach in this case. And I'll come on to another potential benefit of adopting a more precautionary approach and kind of open dialogue towards the end of the presentation. So if we can get the next slide, please. So I appreciate there might be things on this slide that are a little bit of a departure from how you might communicate with regulator in a non-consumer protection space. So bear in mind that our shared goal at Food Safety Authority of Ireland and all of our official agencies, whether you're regulated by the HSE or the Department of Agriculture or a local authority, or maybe the Sea Fisheries Protection Authority, depending on the type of products you make or the type of food business you have, our shared goal is consumer protection. And most businesses, I think, are completely on board with this. I would always encourage businesses to try to build a positive relationship in peacetime rather than waiting for a crisis. So if you're the type of business, maybe a production facility where you're seeing your inspector quite frequently, definitely take that opportunity to build the most collaborative relationship you can. If it's maybe a manufacturing site or a larger facility and there's members of the senior leadership team on site when an inspector comes, it's a nice touch to come down and check in. It kind of indicates to us that, okay, this is a business that takes food safety seriously. They're not just leaving me with the quality or technical manager. It shows that kind of high level engagement with the process. We definitely don't expect you to traipse around the factory floor with us or anything like that. But I think it really helps to demonstrate that commitment and leaves us going away with a positive impression of the business. Again, in my experience, and I've dealt with many outbreaks, incidents, other types of food crises in my circa 15 years as a food safety enforcement officer, the best outcomes are almost always achieved where there's open dialogue between the regulator and the regulated entity. And sometimes that can mean sharing aspects of their company's dirty laundry, and that can be very uncomfortable for businesses. I completely appreciate that. I have worked in a food business myself for a short time in a quality role, so I understand how uncomfortable that can be. However, it really does promote I suppose that openness and that transparency that gives confidence in the business and shows that something isn't being concealed or covered up. In a crisis situation, you may be getting numerous requests from food safety regulators, be that ourselves at the FSAI on our incidents team, or maybe from your local inspector, for information such as distribution details, process flows, extracts from HACCP plans. There could be a huge number of requests, and we appreciate that that's burdensome. But in a crisis situation, there's a very genuine reason for asking for it, and we would always ask that it's provided as quickly as possible. We would also ask that you ensure that any information provided is accurate. And the very last thing we want to see anyone do in a situation like this, where maybe it's a bit pressured and panicked, is criminalize themselves by either forging or altering a document or creating a document that didn't previously exist just to satisfy a request. Again, in my experience, it's much better just to be open about something like that. It's less likely to result in formal enforcement action to take that approach than it is to try and cover a situation up. Finally, and whether this is in a crisis situation or just in a routine official control situation, we understand that there can be challenges with the regulatory process from time to time, whether it's a personality clash with an inspector, whether an inspector maybe is being unreasonable, maybe they're asking you to do things that are going beyond legal requirements, and you're getting that kind of creep into best practice, and it's being framed as though it's a legal requirement. We would always encourage you to try and raise those concerns with the inspector in the first instance. And if you feel that's not going to work, or there are reasons why that's unlikely to be successful in your view, there's mechanisms with all the agencies to raise this with the line manager. So if it's the HSE, for example, they have the Your Service Per Se mechanism. If it's local authorities, there'll always be a formal complaints process. And with ourselves as well, there's a formal complaints process. And if you're not getting anywhere with the official agency, be that HSE or DAFM, you can always approach the FSAI as sort of a last resort there. And there should be no concerns about sort of retaliatory behavior or anything like that. We unfortunately sometimes hear people have had concerns, and it's in very rare cases, and they've not felt comfortable raising them. So please do feel free to raise concerns if there are any. Well, fortunately, I think the majority of relationships between inspectors and the businesses are positive, collaborative relationships. If we can just get the next slide here, please. I'm just going to speak very, very briefly then, just signposting a couple of things really around food safety culture. I'm not going to go into much detail because I am conscious of time. So we'll just bring up the content on the next slide, please. So for anyone who's not already well aware, from the 3rd of March, Regulation EC 852/2004 on the hygiene of foodstuffs was amended. This amendment introduced a number of changes, but one of those was a requirement for food business operators to establish, maintain, and provide evidence of an appropriate food safety culture. Now, there is a degree of flexibility with this. The legislation, as quoted there, states that the implementation of the food safety culture shall take account of the nature and the size of the food business. So allowing for that kind of wide variety of businesses we see, from maybe single person operators and small family run businesses right up to large manufacturing plants, and maybe with many hundreds of staff. But the message I would like to leave everyone with who's listening in today is that the food safety culture must be real and lived, not just a policy and not just an ability of maybe the technical and quality team to talk the talk during audits and hope that that's ticking all the boxes for maybe your third-party certification, or whether it's now during an official control. Unfortunately, the FSAI has encountered many examples, and unfortunately, many of these examples have been in businesses with third-party certifications, supplying into major retailers, for example, where businesses have created quite sophisticated, illusory cultures of food safety that bear no resemblance to what's happening on the ground. Examples, just a few random examples of the type of thing we have seen, where there's a detailed food safety culture statement and some good policies around that, but then you go to the factory floor or you go to the on-site laboratory and you find that the business has been keeping two completely different sets of records, a real set and an audit set, or people have been encouraged to make fraudulent amendments or alterations to records. So those are unfortunately some of the type of things we've seen. I suppose another issue and something to flag in the area around food safety culture, it's a huge business benefit if your staff are comfortable to raise concerns internally if they have them, and that if your staff feel confident that if they raise concerns, perhaps around food safety compliance or other areas of regulatory compliance even, that those concerns will be taken seriously and actioned appropriately. Where staff don't feel comfortable, they're more likely to raise the concerns with the regulator. And we have seen a year-on-year increase in the number of protected disclosures made to the authority. And many of those, and I'm sure you've seen some of the outputs from our protected disclosure investigations in recent years, and I won't name names, but a couple of high-profile prosecutions, closure orders, etc. And in some cases, it's been business ending rather than just reputationally damaging. So I would always encourage you to have robust governance structures in place internally where people are comfortable to raise concerns and, as I say, confident that they will be thoroughly investigated and acted upon. That's an important part of a food safety culture, in my view, and ensuring that your culture is lived down there on the factory floor, that this isn't just a box ticking exercise for audit purposes. Official controls will increasingly take account of this new legal requirement and will consider all levels of the organization, from the CEO level right down to your operatives your general operatives on the production floor, or whatever type of business you happen to run. We do recognize the need for guidance in this area, and additional guidance perhaps from the FSAI in due course. However, the legal requirement is in place and is being enforced as it stands, even in the absence of additional guidance. So just to be aware of that as well. For anyone who is interested, and if you haven't seen it already, the open meeting of the FSAI's Food Safety Consultative Council took place in November, and there was a webinar as part of that open meeting on food safety culture with some great speakers from the US FDA, from Musgrave Group, One Meats, for example. And I'll ask Sinead just to circulate the link to that for anyone who's interested after the event today. It's available on YouTube. So that's really it for me. I know it was a very quick sort of whistle-stop tour, but I suppose just a couple of take-homes just around the impact of open communication and also positive food safety culture when it comes to our enforcement decision-making process. And I'll leave you with this in mind. When we make enforcement decisions following an investigation, we look at a number of factors: the business's history of compliance, the nature of the offending in terms of culpability of the business, whether any harm has occurred, etc. And we tend to adopt a graduated approach to enforcement unless there's been a particularly reckless disregard to public health. for businesses that have a really positive food safety culture in place, that can help to demonstrate that you were doing everything you possibly could to prevent harm from occurring. We understand as regulators that businesses can sometimes make extensive efforts to comply with the law, and nonetheless something goes wrong, and potentially even harm occurs. Having a positive food safety culture, as I say, will demonstrate to us the efforts that you made to comply and can hopefully prevent enforcement decisions from escalating up that pyramid into the formal space, whether that be prosecution, for example, and that's potentially, of course, very brand damaging. So just again, please just remember, it's absolutely fine to communicate openly. You won't be punished for that. And a positive food safety culture is likely to be of great benefit during the enforcement decision-making process. So I think that's it from me, and I'm happy to take any questions during the Q&A session at the end. I'll just hand back to Jamie. Thank you so much.
That's great, Matthew. Many thanks for that very useful presentation, and again for agreeing to be part of the webinar and sharing insights from the regulator's perspective. So next up, I'm going to hand over to Jerry Kelly, head of our intellectual property team, who's going to provide an update on some recent IP case law developments that are of particular relevance to the food and beverage sector.
Thanks, Jamie. Yeah, so I'll do a sort of a whistle-stop tour of looking at food and beverage products and how they are protected in the IP space, if you look at the next slide. And I'll deal with it under the trademarks passing off copyright and designs. I'll fuse it with a number of recent cases, which are giving a few sort of lessons. What I normally start a talk about is the next slide here, where there is looking at what Heineken have done with their sort of branding and how elaborate they have been in trademarking all the sort of logos and insignia and packaging that they have around their beer product, be it the word mark you'll see in the top right hand side, or indeed the bottle itself, right down to having the red star on its own, and that's sort of important. So looking at the area of trademarks, the next slide then moves on to the metaverse, which is where the sort of next sexy area of IP is and how it relates to trademarking and copyright. Can you film on the sort of in the metaverse? How, you know, are things protected around that? But McDonald's has applied for 3 trademarks in the EU and 10 in the United States, dealing with virtual restaurants to ensure that its presence in the metaverse is protected from a branding perspective. Now, that would include perhaps the ability of somebody to be in the metaverse with their Oculus handset or headset and to order in the virtual restaurant, but have it actually delivered in real life. So there is a variety of uses that can be done in respect of the metaverse, but it is quite important that a lot of brands now are quite conscious of this as a new jurisdiction beyond the sort of bricks and mortar and real world, and that the trademark protection is being sought. Ultimately, there will then be trademark disputes when there's a level of crossover, the type of thing we're going to start to see in a few slides. So looking at some other trademarks that people are trying to protect, this is actually a sound mark that was applied for in respect of carbonated products, but it was the sound of opening a can and fizzy sort of that you'd expect to hear in any fizzy drink. So it was a 14-second sound clip. The can opens, there's a 1 second of silence, and there's about 9 seconds as you heard the sort of fizz. So here it was denied protection because it wasn't considered to be, distinctive, an indication of commercial origin to any particular company. Indeed, it was slightly technical, but it wasn't beyond the sort of norms of the industry. So it is perfectly possible to get sound marks, but just they have to be sufficiently distinctive beyond what's sort of normal or customary in the particular sector concerned. If you look at the next slide, you'll see that, for instance, smells can possibly be trademarks. Quite difficult when smell can, obviously, to a degree, like taste, be quite subjective. But there have been some registrations in the UK, not in the food space, but to do with dart feathers that smell like beer or tires that smell like sort of floral fragrances. So that is possible and something we may see develop as time sort of goes on. Looking at a few sort of disputes between parties. The first one is a recent case, which is before the Court of Appeal in the UK. And this had to do with HelloFresh, which is a famous sort of chain, had done a lot of advertising and had this strapline, dinner is solved. Someone came along subsequently and put in halal fresh with a particular type of cuisine, and obviously put in dinner is sorted as a strapline. So not only was the HelloFresh and halal fresh quite similar when you look at it visually and aurally, etc., the strapline being used was very similar as well. So it was just clearly evoking the HelloFresh brand and the reputation around that. So for that reason, it was held that there was a confusion, and in particular that there was this concept of free riding, where whilst there may not be confusion, for example, on the part of consumers, if they associate the Halal Fresh brand with HelloFresh, but no, they're different. HelloFresh is still going around and taking advantage of all the advertising and promotion that HelloFresh would have done, and they're getting a bounce with that. And for that reason, that can be stopped on the basis of trademark infringement. In the next slide, we'll see a famous brand of bourbon from Buffalo Trace called Eagle Rare. That is one of the Sazerac brands. And American Eagle was set up in the UK by Liverpool Gin Distillery. And there was sort of an objection made in respect of that, and it was in the sort of the UK courts. Here we have a situation where Eagle Rare versus American Eagle don't really look or sound that similar. Both have the word eagle, but can you monopolize that? And here it was held based on the type of good concerned. Here, bourbon, quite sort of specialist in a way. And the court took into account the fact that in that sector or specific subsector of a sector, it was common enough for distilleries to have brands which sort of flowed from a theme. So example, Jack Daniels, and then they'd have another brand, Gentleman Jack, or you have Maker's Mark or Maker's 46. So there was definitely a recognition that in that sector, you would have different bottles from the same distillery, but would have slight variations of a theme. So here it was held that whilst Eagle Rare was the only Eagle Rare that they had, both in the 10 and 17-year-old version, the American Eagle was considered to be something which a consumer would be confused into thinking was associated with the Sazerac house of our distillery. And therefore what it was granted here was effectively a monopoly in the word eagle. And that was upheld by the Court of Appeal in the UK. And another case on the next slide is to do with Oatly, which was the sort of pioneer in the oat milk. It did a lot of investment in that, advertising and the like, and had an Oatly brand. And Pure Oatly came along as a sort of a subsequent competitor, and there was objections raised on trademark infringement grounds. Now, looking at Oatly and Pure Oatly, you'll see the packaging isn't really similar between the left and the right, but Oatly and Pure Oatly don't really look the same, sound the same, and therefore there was held to be no likelihood of confusion. And in particular, which is interesting about this case, and that's quite recent, is that the word oat was sort of excised from all of this analysis. It was considered descriptive for the type of product concerned, be it oat milk. And therefore, you couldn't rely on the fact that that was the common theme between the two marks. And in fact, everything else was what you really must analyze. And for that reason, there wasn't held to be a sufficient similarity between the marks. Oatly didn't appeal that decision ultimately and just let the matter rest with competition in the marketplace. But the takeaway from this case in particular is quite important, is that whilst you may be able to get brand trademark registrations for something that contains a descriptive element, that may feed into the ability to enforce it later on. So if you look at the next slide, there's a couple of cases around revocation for non-use in the drinks sector in particular. And this is a Monster Energy case, which they had an espresso Monster product. They had registered for two classes of goods, class 30 to do with coffee-based beverages and class 32 for energy drinks. They're separate classes. Here, Frito-Lay decided to challenge it because it wasn't used, or certainly as broad as the registration had been provided for, which was applied for in 2010. So there's 5 years of non-use in its argument. So here, what the sort of board, the general court in Europe did was they looked at, well, what is an energy drink? What does the Encyclopedia Britannica say about an energy drink, and how are all these types of drinks defined? And on that analysis, they had all the evidence that Monster did actually, as you see on the can there, use it, the espresso mark, for its energy drink. But the general court struggles to see how the evidence was sufficient to protect or retain the coffee-based beverages and the distinction there. Because whilst there was coffee extract in the energy drink, it was at the end of the day, as it's defined in the encyclopedia, an energy drink. It's infused with some coffee, albeit a very small proportion, but it's not a coffee-based beverage. There's no sort of brewing of coffee involved in the process of manufacturing it, etc. And therefore, it was considered that Monster could keep the Class 32 registration, but not the Class 30 registration on the basis of non-use. If you look at the next slide, we're probably all familiar with Avonmore Super Milk. It's been for sale for over 20 years. And here, there was a challenge made for a trademark, which was simply the color red for dairy products and fortified dairy products with vitamins, etc. And it was argued by the challenger, excuse me, that the red that was applied for became generic for fortified type milks and the like. So, excuse me, it designated a type of milk product. Here, the controller of the Irish office decided that there was not a generic use of the mark, that whilst 94% of the market was with Avonmore Super Milk, just because somebody else may have come along and used red with fortified milk, that's mimicking the main party in the market, and that isn't considered to make the whole issue of red in fortified milks generic. And for that reason, the revocation action was dismissed. So it was possible to maintain it. So if we sort of move on to a final slide on trademarks, this is the most recent, albeit not that recent because it's pre-COVID, case that's come before the commercial court in Ireland in a dispute around product names and the like. And the marks here were Nutriplen. That was the product that was alleged to be infringing the Nutriplete European Union trademark. Now, Nutriplete was not being used at that particular time, but it was argued that Nutriplen was infringing it. They are very similar. They start off very similarly. They both have obviously Nutri. And for that reason, it was held that there was an infringement. What's interesting about this case and how it was tried to be defended was that it was argued by the defense counsel that the packaging of the product was very different to how Nutriplete had been mocked up at that point. It wasn't on sale yet, and therefore there wouldn't be confusion. But that was dismissed, as it rightly should be, as added matter. And you don't take that into consideration in a dispute around trademark names. It'd be slightly different if you were registering a packaging. So here, what the court does is it simply looks at the names in isolation. What was equally interesting about the case is the issue of damages or unaccounted profits. And here was held that because the plaintiff had acted in a bad way, there was a poison pen letter written, you couldn't under equity get an accounted profit, you could only get damages. It's one of the few cases in the Irish courts which sort of looks at the monetary remedies. And again, decided based on expert evidence that the damages here were about €35,000, again, based on no sales. If we look again on the next slide, we deal with passing off. There's a case, and the main case we've probably seen in the media. Again, it's going back a little while now, but this is the McCambridge's and Brennan's Bread case that went all the way to our Supreme Court. And what's interesting about this case was that McCambridge's didn't have trademarks or anything around their packaging. If they did, it would be a slightly different story. They were relying on unregistered trademark rights under passing off, and that their packaging was sufficiently well known that consumers would look at it and immediately consider it to be from the McCambridge company. Then when the Brennan's Bread came out, which you can see here is quite different, that was held to be passing off because there was sufficient goodwill in the packaging, the sort of clear packaging with the labeling, that seeing the Brennan's product would deceive customers. Then if we look at geographical indications very briefly, this is another way of protecting types of products in the food sector, but simply where there are what would be considered geographical indications. If you look at the first slide here, we have a most recent case in a German court, which had been in the Court of Justice, and that was around the use of the word Glen with German whiskey. The Scottish Whisky Association took exception to that. Scotch is obviously a geographical indication that's protected. It has to come from Scotland, very much like Champagne comes from the Champagne region. But Glen here The way the regulations are set up and the way this was sort of presented to the Court of Justice was, does the word Glen actually infringe Scotch whisky as a geographical indication? Is the word Glen denoting a valley in the Scottish Highlands evocative of Scotch whisky, such that a consumer doesn't have to be confused? But again, like the free riding point I made, there is a sufficient association with Scotch whisky for this German whisky that it would be infringing the geographical indication. The National Court, ultimately after the Court of Justice, held that there was. But what was equally important about this was that the Court of Justice held that that's the analysis you do. The fact that it was saying on the label of the German whisky that it was German whisky, and not necessarily disclaiming it wasn't Scotch whisky, was irrelevant. Additional text, disclaimers or anything like that aren't going to matter. If we look at the next slide briefly, this is where a gin company tried to apply for Porto or Porto gin, and this was objected to by Porto, and obviously it's considered to be a sort of port wine from Portugal. And this was an analysis of, again, it's not an exact replica of Porto. There is a sort of a word, a sort of letter in the difference, etc. But it was sufficiently close that it evoked the Porto geographical indication and all the good will that goes with that, that it could successfully object to the Porto gin brand, even though there's port wine and gin. So it's interesting to see that when you're coming up with branding, you may have to make sure that you're not necessarily infringing on geographic indications, even if they're not exactly on touch. So then looking very briefly at copyright and how that sort of come into it. The first slide here is a case, again, going back a little bit, where copyright has really come on in the sense of what it protects. It's quite strict in that you have to have a work, but the protection that it gives, is for quite a long period of time, and it can be quite sort of lucrative in how it's enforced versus trademarks. Here there was a taste, and there was an attempt to try and suggest that that was copyright protected. Now, the Court of Justice held it can't be, simply because it is something which is very subjective and therefore can't be identified with sufficient precision, clarity, objectivity to be copyright protected. And for that reason, taste couldn't be protected by copyright. That's not to say it mightn't be protected by trademarks, as we looked at slightly a little earlier. But again, we'll see if somebody gets to crack the nut in protecting a sort of particular taste. In the next slide, we have just some examples of where scent or smell, as I mentioned in the context of dark feathers, etc. This has been held to be copyright protected in certain circumstances, in not necessarily the food sector. But so again, you could have these potential that a particular food product could arguably be protected by copyright, but you may have to, deal with potential objections around clarity, objectivity, and the like. Then finally, just looking at how packaging in particular can be protected. This is to do with industrial designs. And industrial designs is probably the weakest of all the IP rights. It's never really asserted to a large degree. And what this is, it just simply protects the appearance of a product, be it through the lines, contour, shapes, colors that go on the packaging. Here are some examples on the EU registry. You'll see a crocodile-shaped gummy sweet and the Benecol packaging. So this can be useful in sort of protecting products. Now, it's not as good as trademarks, because trademarks are renewable every 10 years for infinity, whereas these designs will be renewable every 5 years, up to a maximum period of 25 years. After that, it's in the public domain. That may be suitable for certain packaging that's going to evolve and may not be the same in 25 years' time. But so it does have a limited enough use, but it is something which is useful in obtaining sort of registration and protection around that, that may not sort of succeed, let's say, in the trademark space. So that's me on the IP protections, and I'll pass you back to Jamie.
That's great, Jerry. Thanks for that comprehensive update on IP as it relates to food and beverage products. So now moving on to our third and final segment, there are a number of recent and upcoming employment law developments that business owners should be aware of, and food business operators are certainly no exception. So now we have Ronnie Neville, a partner in our employment and benefits team, who's going to bring us up to speed. So handing over to you, Ronnie.
Thanks, Jamie, and hello, everyone. If you could go on with a couple of the first slide. So, I mean, any business that is labor intensive, and certainly food and beverage industries and businesses in the food and beverage sector in particular tend to be labor intensive, and therefore a lot of important recent developments in employment law and a lot of important developments which are coming down the tracks are going to impact on the food and beverage sector in particular. So in recent months, we've had two really big decisions, which I want to just tell you about very, very briefly. It's going to be a whistle-stop tour because I want to tell you a lot in a very short period of time, but you have the slides, so you'll be able to refer back to the slides and go for a deeper dive, come back to us, certainly, if you want any further details. Two big decisions. One was only in the last 2 weeks on the Domino's pizza case, which is a really important decision because it puts a spotlight again on something that has always been contentious, which is, are you a contractor or are you an employee? The other big decision was from December of last year, which is the Baranya decision, which again put the cat amongst the pigeons for employers in relation to what was previously understood to be an exclusion from protected disclosures, which are whistleblower claims, if it related to your personal grievance. If that meant that it was going to be excluded, the Supreme Court says no. May 2022, we've got the introduction of the Gender Pay Gap Information Regulations. That is now law. If you don't have your system set up for gender pay gap reporting, and if you come within the relevant threshold, that's a problem for you. I also want to touch on other upcoming developments coming down the tracks, in particular those that are, particularly to the forefront of the mind coming out of COVID, that talk about employment welfare and employment protection in terms of remote working, work-life balance issues, also now coming more in keeping with European norms around right to disconnect, paid sick leave, and also importantly, an update to our protected disclosures legislation. That's all stuff that's coming down the track. Okay, Sinead. And again, yeah, thank you. So first of all, in relation to the gender pay gap regulations, it's in law since May 2022. It provides for a framework for calculating the pay gap between males and females, and it provides a framework for how employers are going to have to publish reports outlining specific information around their pay gap. It currently applies to businesses with over 250 employees. That's from 2022. From 2024, it applies to businesses with over 150 employees. From 2025, it applies to businesses with over 50 employees. So for those of you in the session, in the talk, who are smaller, less than 250, take note that these regulations will apply to businesses with fewer employees. If you've got over 50 employees, it's coming for you, and it is important from 2025. Once you compile your report, that report then, which might contain information that that might embarrass or cause concern for businesses, has to go on your website, or it has to be published in written form. If you don't have a website, no one doesn't have a website. Apologies, a double negative, but who doesn't have a website? Go on again, Sinead, please. So what calculations have to go into the report? It requires you to publish both the average difference in hourly pay between men and women, the median difference between pay for men and women, also, which can be controversial, information by gender on exactly where the genders fall into the different levels of the organization, whether it's graded or in terms of seniority by reference to pay. Go on again, please, Sinead. Although there aren't financial penalties, in the event that either the Human Rights and Equality Commission are concerned that you're not making your reports, or an individual employee, either of those can bring a claim either before the courts or before the WRC, which have the power to make an order for the employer to make its report and to publish its findings. If the UK is anything to go by, the fact that there isn't a financial penalty will not, to my mind, give a pass to employers in relation to not having its house in order when it comes to producing these reports. And the report, importantly, I think I glossed over it a moment ago, requires the employer to provide an explanation for why there are significant differences either in the median or the mean averages between pay, and on measures to try to remedy those differentials. What we've seen from the UK is that it can be really controversial and difficult and embarrassing for organizations to explain. So arguably the lack of financial penalties may not, prove to be an issue or a lack of a deterrence for employers to avoid their obligations, to improve their lot when it comes to gender pay gap equality. And that's because, organizations in the context of the court of public opinion do not want to have a spotlight shone on what are obvious discrepancies in terms of pay, and also on their failure to have an appropriate system in place to report and to have measures in place to try to improve. Go on now, please, Sinead. Two big decisions. The Domino's pizza case from only 2 weeks ago. Revenue initially deemed their pizza delivery drivers to be contractors and to fall outside the scope of PAYE. Revenue deemed them to be employees. Domino's argued that they were contractors and fell outside the scope of PAYE because they were on contract for services. Revenue said no, we actually believe that they fall under contract of services. On appeal before the TAC, the Tax Appeals Commissioner, Revenue's arguments were upheld, went to the High Court, and the High Court upheld Revenue's view. And Revenue looked at some of the stuff that you folks as clients may hear us discussing or others, because when you look at the issue around contractor versus employee, where does it become relevant? The employee might bring a claim and say, I'm an employee. Revenue might take issue with you and say, these are employees. Social welfare might independently of the other two take issue and say, no, these are de facto employees. What are the tests? You look at mutuality of obligation, which means I am going to, as an employer, I am obliged to give you work. From an employee's perspective, you're obliged to give me work. I'm equally obliged to perform work for you. So there has to be that mutuality of obligation. And in the absence of that, you're a contractor. But sometimes it's really difficult to work out where the lines are in the context of whether someone is actually a genuine contractor, which is a bit more free and casual, or whether there is some element of mutuality of obligation to provide work, to perform work, which means you fall under employee status. There's other tests like how integrated you are, whether you can substitute workers, which suggests independence, and the terms of the contract. They also looked at UK legislation. Would you move on, please, Sinead? The Court of Appeal said that Revenue's position and the High Court made errors in finding that there was mutuality of obligation. The Court of Appeal said that on the facts, the drivers, there was no actual requirement on the drivers to make themselves available, even though when they signed up, they had to give their notice of unavailability and say, oh, I'm not available tonight or tomorrow night or whatever it is, and which would suggest some degree of obligation on their part, because if they're required to signal their unavailability, that would suggest that they're required to make themselves available. But because on the facts, there wasn't any sanction in the event that they didn't actually perform the work or turn up, that meant that it lacked that crucial mutuality of obligation. The Court of Appeal decided we don't have to look at these other tests, integration, substitution, etc. The core test of mutuality of obligation wasn't met. And therefore, the takeaway for you as businesses, in particular those businesses, or maybe only those businesses who have occasion to rely on contractors, to use contractors. This is important to you because it means that what looked like a really worrying decision from the High Court saying that contractors would fall under the umbrella of employment, which has significant tax consequences as well as others, as I say, social welfare and employment claims, now it seems to reduce the burdens on employers to say, no, under the contract, you are genuinely autonomous, free, independent, no mutuality of obligation. And to that extent, it seems to give some degree of comfort to employers. But again, it depends on the facts of the case. Next slide, please, Sinead. The other big decision from December of 2021 was Barania, where an individual, Mr. Baranya, who had made a number of complaints around back pain, and he made a further complaint 3 days before he was then dismissed. And post-dismissal, then he maintained that he was dismissed for making protected disclosure. He'd never mentioned protected disclosure prior to that point, but he did say then after the event, I complained about back pain, therefore that constitutes a protected disclosure in the context of the work that I was performing, and therefore my dismissal was then penalisation for making a protected disclosure, blowing the whistle. The Workplace Relations Commission of the Labour Court said there's an exclusion under a code of practice which gave really helpful guidance to employers around, you know, how to manage protected disclosures and what fell within the scope of protected disclosures and what was relevant wrongdoing. The code of practice said if it's a personal grievance, that's not a relevant wrongdoing. And the High Court agreed with the Labour Court to that extent. Next slide, please, Sinead. The Court of Appeal, the Supreme Court, this is why it's obviously so significant. Judge Hogan, who is a magnificent judge for really well-reasoned decisions, particularly when it comes to constitutional issues in particular, gave a decision which effectively caused everyone to realise for the first time that the code of practice went way off script. The Protected Disclosures 2014 Act made no reference to grievance at all. And therefore, the code of practice, which suggested that grievances which are personal to the individual should fall outside the scope, simply had no basis in law. But more particularly, what Judge Hogan said, and there were three decisions published, two suggesting that this was a protected disclosure, and one dissenting. But Judge Hogan was the dominant judgment, and effectively separate to the issue of whether it was a grievance included or excluded from protected disclosures. Once an employee makes complaints around issues which relate to health and safety, then the fact that it's a personal grievance to themselves does not mean that it won't be a protected disclosure, because raising health and safety issues come within the examples of what relevant wrongdoings are under the 2014 Act. And therefore, when an individual raises health and safety concerns, which could be an issue not just for the employee and for others, that then will come within the scope of protected disclosure. It really seems to broaden the scope of protected disclosures legislation. And it's a real concern and something that employers need to take note of. If you've got an issue which could be a health and safety issue for employees generally, and there's only one person knocking on the door saying, I'm taking issue with this, the previous view would have been, that's not a protected disclosure, it's personal to them under their contract of employment. Judge Hogan's decision now says, any issue which constitutes a health and safety grievance now comes within the definition of relevant wrongdoing, and therefore it's very significant for employers generally. Next slide, please. And again, please. Now let's focus on upcoming developments. And there's a bit of a segue from Judge Hogan's decision into this upcoming development, which is a new bill which has been published. And again, it's, there was an anticipation that if the legislation as framed and as correctly adjudicated by Judge Hogan allows for a situation where a much broader interpretation of what a relevant wrongdoing is, to the extent that any issue that an employee flags, which could apply like a health and safety issue to workers generally, that this would be the opportunity for government as the appropriate lawmaker to refine it, because otherwise it places a very significant burden on employers. That hasn't happened. If anything, the new law is going to broaden the definitions and scope of the whistleblower legislation further. At the moment, there's no legal obligation from the private sector for their policies for whistleblowers. The big thing about the protected disclosure legislation is it's going to require employers to put in place reporting channels and procedures. Previously, those existed for the public sector. Now they're being extended to the private sector. Relevant wrongdoings have been broadened, not restricted. Worker definition is being broadened, not restricted. There's a new definition of penalisation. Next slide, please, Sinead. Significantly, if an employee claims that they've been penalised, any less favourable treatment as a result of taking issue with or objecting to or flagging or raising concerns, and someone suffers less favourable treatment, The burden of proof now goes on the employer to say, in respect of that treatment, which the employee claims as penalisation, I now have to justify it first. A bit like an unfair dismissal claim, it's a significant thing for the employer to have to go first because it goes against the natural position that the employee or the employee who's making the claim has to make their claim. It also provides for new offences. Those reporting channels, currently it's 249 employees, and it's going to reduce down to 50 employees from 2023. So those obligations to put in place channels, I and my colleagues in Mason Hayes, the employment team, have been surprised about the lack of take-up. Effectively, the lack of use of protected disclosures, whistleblowers by employees. There's been a few big ones that you might have heard about, but it's a huge weapon in the arsenal for an employee who's looking to bring claims against their employer. Now, if there's been a lack of awareness of it or spotlight on it, it's going to be front and center in employees' minds because it's going to now form part of the handbook. It's going to be a legal requirement on the employer to upfront inform employees of these reporting channels for businesses from next year with only 50 employees. And I think that that's going to result in an uptick in whistleblower claims. And it also provides obligations, timeframes for the employer to respond to complaints and how to deal with it. Next slide, please. I'm going to fly through this because we're under pressure for time, but we have a few minutes for questions. These are not bills yet. This is a draft scheme, but it does provide for, because a lot of the mood music is very much within society and amongst legislators is very much one which is seeking to foster and bolster better protections for employees and to allow better flexibility to request work from home. There's a lot of criticism, if you go to the next slide, there's a lot of criticism of this draft scheme, which will become the bill. Employees are saying it doesn't go far enough because there's too many excuses for the employer. Employers are saying it goes too far because it puts an obligation on employers which for business reasons might be excessive. So I would expect that bill once it's published to be amended, but there is going to be some legislation in the, if not imminent, in the short to medium term, for providing for work, at least the right to request the right to work from home. Whether the employee gets it or not is another thing. Next slide, please. Work-life balance provisions bill, again, very much part of the obligations or the goal of providing better protections and working life for employees. As I say, particularly come out of COVID, employees who have 6 months can make a request. It doesn't mean that the employer has to accede to this request. So if an employee has children up to the age of 12 or has caring responsibilities, then it will now have a right to make a request for flexible working arrangements. There's not much in the scheme which provides for, in the same way that under the previous draft scheme that I talked about, provides examples of what the employer's potential response or basis for rejecting the request might be. That's not there yet. Equally, there's no provision yet for penalties, but there is going to be provision for a right of an employee to make a request for flexible working if they've got child caring responsibilities or if they've got caring responsibilities. And I suspect that there's going to be some type of penalty provisions for employers who at least don't go through the process of properly examining these requests, and potentially for not acceding to requests unless there's an objective basis to refuse it. Next slide, please. There's going to be changes as well, expanding provisions for breastfeeding. It's a big one. At the moment, you've got breastfeeding time to be made available for women coming back from maternity leave. Is currently for 6 months. It's going to be extended to 2 years, and it might now be extended to transgender men maternity leave entitlements. Again, a big thing. It's likely to be controversial. And also that people could make request for something that's different to force majeure leave, that they could request 5 days of unpaid leave if there's serious medical reasons where they have to provide care. And that's different to dealing with an emergency under force majeure. And the next slide, please. Sick leave. We have never had sick leave mandatory sick leave in Irish law. This is a big thing across Europe. We're kind of out of kilter because, you know, it's you know, to say it in a broad brush way, there's more of a socialist or protectionist environment in mainland Europe, but even in the UK, they've got company sick pay. We've been an outlier to that extent. We're now introducing it. It's going to be quite modest because there's got to be a 70% of an employee's wage will have to be paid, and it's going to be incrementally increased. So from 2022, you have a right to 3 days, then 5 days, 7 days, then 12 days, and then 10 days from 2026. So it's not significant, but again, for those employers who have, you know, low earnings, large numbers of workers on modest wages, because, you know, generally speaking, mid-tier and senior execs would already have sick leave provisions, sometimes generous sick leave provisions, but it doesn't tend to form part of the contracts for lower earners. But now there's got to be a provision, and it could stack up if you've got to go 2 weeks paid sick leave for a large workforce of lower paid workers, then it could add significant amounts to the wage bills. Next slide, please. And then I'm finishing up auto enrollment. There's going to be, from 2024, a government scheme. And of course, this is protectionist. Employees are not making adequate provisions for themselves. And there's got to be a requirement for employers to auto-enroll into this government scheme within certain parameters. Employees between 23 and 60, they have to earn more than 20. They can't already be a member of an occupational pension scheme, and will be capped up to a maximum salary of 80,000. Next slide, please, Sinead. And then the amounts for enrolment are set out there. The employee will be required to make a contribution. The employer will make a contribution. The state will make a contribution. Everyone knows that there's a pension bubble or you know, explosion, which is imminent with aging workforce and with the fact that the state will be unable to continue to pay significant state pensions, absent the employees making better provisions for themselves, which they're not doing at the moment. That's the basis for auto-enrollment coming in. I think that's it.
Okay, thanks a million, Ronnie. Plenty of useful updates there, and obviously lots to keep track of at the moment on the employment front. So that concludes the presentations making up this morning's session, and hopefully you'll be able to take away a lot of really useful information in terms of protecting your food business when it comes to food safety, intellectual property, and employment law issues. We've run a little bit over time, and there have been a few questions that have come in. I think just to even take one, which was addressed to you, Matthew, I think, and it was, the question was, what can a business do if, despite their best efforts, they cannot develop a good relationship with their local inspector?
I think in the first instance, it's just about starting with a conversation with that inspector's line manager and escalating from there as appropriate. And I suppose it all depends on what the particular issues are. Is it an actual conduct issue, or is it just sort of a clash of personalities? So look, it's a difficult question to answer in that sense, but starting with a conversation with the line manager in the first instance, I think is the way to go.
Okay, great. Thanks, Matthew. I'm just conscious of the time. So on that basis, I think all that remains for me to do is just to thank our speakers for their contributions. Also to thank you, the audience, for your attendance and attention. We hope that you found the session useful. We would ask that you just take a minute to complete the survey that's going to pop up on your screens, as we're always grateful for your feedback and suggestion for future topics that we can cover on our webinars. So thank you. Enjoy the rest of your day. Please don't hesitate to get in touch if you need further information or advice on any of the topics covered this morning.